Jacobs, Senior Advocate of Nigeria. The second would be by Mr. Raphael Onwuzilibo. So a brief citation of Mr. Rotimi Jacobs, who you will all agree needs very little introduction in our community and our profession, but nevertheless, we have to treat him as we've treated other tutors by reading a citation. Rotimi Jacobs, Senior Advocate of Nigeria, was born on 12th May 1962 in Ikere, now Osun State. He attended primary and secondary schools. Rotimi Jacobs' son was at the Kwara State College of Technology for his higher school certificate from 1982 to 1985. He came out in flying colors in his A-levels. As to the choice of his university, Rotimi Jacobs' son carefully chose the Nigerian Premier University, University of Ibadan, for his LLB. He graduated from the university in 1988 and immediately proceeded to the Nigerian Law School, Lagos, for his BL. He was called to the Nigerian bar in 1989. Had his National Youth Service Corps, he was originally posted to a local government, but not being a man given to idleness, he chose to serve at the chambers of late Chief Gani Fawemi Sam, where he knew he would face challenges that would prepare him for the future. Tayo Etibosan was the deputy head of chambers at the time. Quite unusually and owing to primarily to his devotion to duties, hard work, and commitment of purpose, Chief Gani Fawemi San gave Rotimi Jacobs San a letter of employment 2 months before the completion of his NYSC program. Since employment was already waiting for Rotimi Jacobs San before the completion of the NYSC program in the chambers as challenging as that of Chief Rotimi Williams, he gladly took up the appointment in 1990. He was with Gani Fawemi and Co. till he rose to the position of deputy head of chambers in 1984 when Ayo Olarewanju left the chambers. As the deputy head of chambers, he understood the enormity of the task before him, and in that regard, he provided good leadership for the junior counsel in the chambers. Also, while in Gani Fawemi chambers, he was a member of the Nigerian Weekly Law Report editorial board. In 1997, he left Chief Fawemi's chambers to establish the law firm of Rotimi Jacobs and Co. In 1999, Rotimi Jacobs was appointed Special Assistant to the Honorable Attorney General and Minister of Justice of the Federation, Mr. Kanu Agabisan, who ironically met Rotimi Jacobs in the defamation case, and in which Rotimi Jacobs had appeared as an opposing counsel. And on it goes. It is my pleasure this afternoon, therefore, to introduce to you a man who has done so much in litigation, and especially in criminal litigation in Nigeria, has been known to handle most of the external prosecution cases for the EFCC. And we're grateful to him today for agreeing to take on this session. Of course, those who were here a week ago today will remember his very insightful commentaries on the session that was led by Mr. Victor Obara. So it is my pleasure this afternoon to yield the floor to Mr. Rotimi Jacobs, Senior Advocate of Nigeria. Learned Senior Advocate of Nigeria, you're welcome. Thank you very much.
Thank you. I hope you can hear me.
Loud and clear, sir.
Yeah, thank you. You know, I must appreciate your the effort by the MBA Institute of Continuing Legal Education, MBA course session, criminal litigation training, to discuss an aspect of criminal litigation, presentation of case for the defense. It is a serious business, and it's an Herculean task for a litigation lawyer to represent a criminal defender in a criminal trial. The expectation of the court, the judges, that he must perform his function professionally and discharge his function well, and give proper advice, to take proper steps and necessary steps in pursuit of justice, and as an officer of the court to play his role. Now, the client also expects the defense counsel to do wonder and do something that other people exonerate him from the allegation made against him. So the perception of society is also not so favorable to the defense counsel, in that they see the defense counsel as a person set out to suppress crime and then collect money from particularly the rich defendant, which is not right. So because a person charged and accused of a crime is entitled to counsel of his own choice. Now, this training program is in line with Rule 11 of the rules of our professional conduct for legal practitioner, which make it mandatory that the legal practitioner shall participate in and satisfy the requirement of mandatory training professional development program operated by the Nigerian Bar Association. And I guess it's in line of that rule that the MBA, Institute of Continuing Legal Education, put this program in place to enable every one of us to participate in this mandatory training. I thank you very much for the opportunity given to me. Now, our subject in this discussion is on the presentation of the case of the defense. The observation, the first observation I would like to make is that the topic assumes that the prosecution has called his case, called his witnesses, and adduced sufficient evidence, which clearly reveal that there are prima facie cases against the defendant, and thereby calling upon the defendant to make out his case. However, the presentation of the case for the defense appears to me not to commence at that point after the no case submission has been overruled, or after the prosecutor has closed his case. The defense counsel is expected to present the case of his client, even through the prosecution witnesses, by cross-examining them and turning relevant documents through them to support his defense. It may even commence while representing him during investigation, because just like alibi, you can't come to court and say, I'm raising the defense of alibi. It is your duty to advise your client at the point of making statements to raise whatever defense he has, particularly defense of the investigator, to investigate such defense. So it may be too late before you make that presentation. So the case of defense start from investigation, but we will not go into the area of investigation because of the length of work that this topic actually require. Now, the case for the defense is the systematic and logical presentation of the case of the defendant accused of a crime before a court of law by his lawyer. It is on this note that even the counsel is referred to as defense counsel or simply defense. The role of defense counsel is to protect his client against unjustified and unmerited conviction, punishment or sanction for the offense he did not commit, or to minimize or reduce the punishment that would have ordinarily been inflicted upon him. Now, the defense in a criminal matter is a denial of prosecutor's charges or allegation. It's the duty of the defense counsel to bring out the evidence in rebuttal of the evidence adduced by the prosecution. However, before he can do this, he must have this basic quality. He must prepare himself properly to understand the allegation made against his client, the defendant, and the nature of the offense alleged against him. He must know the ingredients of those offenses and the evidence required to establish those ingredients. the defense is available to his client, the legal issue involved in the case, and all those relevant things. So a defense lawyer is expected to have knowledge of both the substantive and the procedural law governing the case, so that he will be able to perform his role effectively. Now, what are the tools for presentation of the case of the defendant? Now, I said it is not at the point of when the defendant is called upon that the presentation starts. In fact, the major case, the best lawyer, what they do is that they almost establish their, or in most cases, establish their case through the prosecution witnesses. So effective cross-examination of prosecution witness is a veritable tool upon which the defendant can clearly present his case before the court. Now, the presentation of the case of the defense in court normally commences with the examination of prosecution witnesses by the defense counsel. Cross-examination of prosecution witnesses is a very crucial aspect of presentation of defense case. Now, if you look at section 36(6)(d) of the Constitution, it grants constitutional rights to the defendant to examine in person or by his legal practitioner, the witnesses called by the prosecution before any court or tribunal. Now, that rights are also repeated and enshrined in our Criminal Procedure Act and law, particularly the Administration of Criminal Justice Act, Section 300, is also in all the Administration of Criminal Justice law of various states. Now, that right is given to the defendant, that the right to examine in person or by his legal practitioner the witnesses called by the prosecution before the court or the tribunal. Now, where the prosecution call any witness, that prosecution witness must be yielded to the defendant for the purpose of cross-examination. Failure to yield him to the defense to cross-examine him will make the evidence irrelevant, which is liable to be expunged. You will see the case of Okoro and the state which I referred to there. The prosecution witness gave evidence, and then he failed to yield the witness to the defense to cross-examine. And now the defendant must cross-examine the prosecution witness on every material fact in controversy which the defendant does not agree or accept. Thus, the defendant must at least make the witness to be aware that he did not accept his testimony or the fashion of the story which is telling the court. And it is not a good practice to say, no, I'm not going to cross-examine him on the material point, and I'm going to lead my own evidence to later contradict what the prosecution witness says. No, it's a bad practice, and the decision of court is to defer that such evidence of rebuttal given thereafter, when you left the witnesses on cross-examined on that point, cannot charge the authorities that are put in the paper of Folete and the state, law and the state, and Okasi, and so many other cases on that. Now, cross-examination of prosecution witness is to destroy or damage the case of the prosecution, but principally, the purpose of cross-examination is for you to establish your own defense. So you establish your own case, because the prosecution witnesses are probably people who witnessed the incident that were there, so you can extract your own evidence through them. And I put the authority of Joe and the state, where to be JSC said, the main aim and objective of cross-examination is to destroy or damage the case of the prosecution and to make the court believe that the accused did not commit the offense, or even if he committed the offense, there are valid defenses available to him. It is also for him to build his own case. Now, the purpose of cross-examination is to weaken or damage the case of the prosecution, bring out his own defense, cast reasonable doubt in the case of the prosecution, strengthen or fortify the case of the defense, convince the court that the defendant did not commit the offense. Even if the offense was committed, there are valid defense available to him, and discredit the testimony of prosecution witnesses. That is the act of cross-examination is an act. It's something that you must learn. I don't expect any defense counsel not to master the art of cross-examination, because that is, in most cases, that is where good lawyers win their cases. So that is where you establish your defense. That is where you weaken the prosecution's cases. So it's an art that everybody is expected to learn. Now, the next tools that you use is the resting of case on the defense of the defense on the prosecution. You can rest your case on that of the prosecution. And how is this done? After effective cross-examination, and you discover that there is nothing done by the defense, now it is permissible to rest the case of the defense on the prosecution, rather than starting with the opening address or leading evidence. One of the options open to the defendant at the close of prosecution case, when he's called upon to prove his case, is to rest his case on the prosecution's case. Particularly, it is advisable to adopt this procedure where the case of the prosecution is apparently weak in law and in fact. The case is such that even if the prosecution witnesses are believed, yet the offense as charged is still unproved. Now, the prosecution case does not call for any explanation from the defendant, and there is no defense. You don't have any defense that will require issue of fact that the defendant needs to give evidence to support. In such a case, you can rest your case upon. Hello? You are not hearing me? Hello?
We can hear you, Leonard Silk. We can hear you.
Yes, thank you. Now, where there is no scintilla of evidence linking the defendant to the commission of the offense charge or similar offense with which the defendant could be convicted in lieu of the offense charge, then he can rest his case upon. The difference there is that it is not when you are considering a no case submission or resting your case on the defendant, you don't just look at that charge, because under the Administration of Criminal Justice law, another law regulating procedure, the court is mandated to look at the charge or look for alternative charge or lesser offenses that the defendant can be convicted of without necessarily charging that person expressly for that offense. So, in deciding when that evidence that the prosecutor has led, is he going to support other similar offenses or lesser offenses before you take this decision? Now, the prosecution, where the prosecution failed to prove the case beyond reasonable doubt against the defendant, you can rest your case. Now, there is need for caution. The court have been warning that lawyers need to take caution in resting his case on the prosecution's case. I put all those the caution. The defendant cannot, because if you rest your case on the case of the prosecution, you cannot change your mind thereafter and say, I'm going to call my witnesses, because that defendant is foreclosed. Now, not only that, where explanation is required from the defendant, it will be unwise for the defendant to rest his case on the case of prosecution. I refer to Edet and some other decision on that. Then it is a legal gamble and very risky to rest your case where the prosecution has made out his case. So I stated what the appellate court has said on that lawyers need to tread softly in resting his case. Now, if you have looked at the second option of resting your case, the third option is to, if you decide to call witnesses and you are not resting your case on that of prosecution, is to begin with the opening speech or opening address. Is a tool for the presentation of the case of the defense, is an opportunity for you to summarily inform the court, make comments on the prosecution's evidence, and also the kind of evidence you want to lead, the people you want to call, and the facts you want to elicit from those witnesses. Is provided for under Section 301 of Administration of Criminal Justice Act. Is also in Section 192 of the Criminal Procedure Code and 241 of the CPA. So opening address is not mandatory. It just give you an opportunity to allow the court to know what you are about to do and explain to the court the step you want to take, and so that the judge will be able to follow your witnesses. So that is but it's not mandatory It's not, you can foreclose it, you may decide to waive it. So the denial of the right of opening speech, it may not even affect, it may not prejudice the defendant. And I cited authority on that. But in Nigeria, we don't normally do that. Prosecution will just start, put his witness in the witness box, whereas in other jurisdictions, these provisions are in our laws, but we don't use it. So you can start with your opening address to enable the court to know your case, the theory of your case, where you are going. So that is the tough thing to do. Now, the next step to take is you are a defense counsel. You have a big decision to take when you have decided that I want to call witnesses. The first decision you take is to look at the provision of the Act, particularly Section 358 of ACJA, Section 287 of Criminal Procedure Act, Section 236 of the Criminal Procedure Code. All these sections of the law we enable the defense counsel to take a decision. If I'm going to call witnesses, am I going to call the defendant to give evidence in the case? Now, there are three options. Three options are provided for in those sections. Where a defendant is represented by counsel, his counsel must explain the three options available to the defendant whenever he is called upon to make his defense. So if it's not represented by counsel, it is the duty of the court to explain the three options available to him. And failure to do that will nullify the proceedings, as was done in Josiah and the state, and Saka and the state. So now these three options are prescribed by those sections of the law which I have earlier referred to. Now, the first option that the defendant can make out of the three options, so you as a defense counsel, you must advise your client. You have three options, and the three options are these. You can make mere statement from the dock, from where you are as a defendant. I'm sorry. So statement will be made. It will not be sworn. It will not be cross-examined. So it's just a mere statement. The defendant, in appropriate case under section 3581A of ACJA, may make statement from the dock without being sworn, without being cross-examined by the prosecution or the co-defendant. So the defendant only presents his defense from the dock without being sworn and without being cross-examined. Such statement is not sworn evidence that may be liable to be cross-examination. The court is entitled to attach weight to the statement made from the dock by the defendant as he thinks fit. The court is enjoined to take such unsworn statement into consideration in writing his judgment, whether the prosecution made out a case or in deciding whether the prosecution made out a case or not. In the case of Farrow and Frost, in that case, it's an English decision, the defendant did not give evidence. The judge decided that I will make statement from the dock, and he made statement. He was not cross-examined, and the judge said, just passing remark and said, it's just a mere statement. I'm not bound to consider it. And the appeal court said, no, it's a statement. You have to look at it and view it in line with the prosecution's case, and you can attach weight to it. You may not attach much weight to it because there was no cross-examination, but you must look at it and make comment about it in your judgment. So it's not just a mere statement. So now, the courts in practice do not place much weight on a mere statement made by the defendant from the dock without being cross-examined by the prosecution. In fact, in England, the practice has been abolished, leaving only two options, because we borrowed that section. That's section 358 from Criminal Justice Act of England. So in 1982, they abolished this first option, that if you want to give evidence, you have the right to not to give evidence at all. But the moment you want to give evidence, you can't make mere statement that nobody will cross-examine you. They abolished it in England in 1982, but it's still part of our law in Nigeria. Now, the second option is to give evidence in a witness box after being sworn and liable for cross-examination. The second option available to the defendant under section 358 of ACJA is the right of the defendant to give evidence in the witness box after being sworn as a witness, in which case he will be liable to cross-examination. It is a tough decision to make by any defense counsel, whether it is appropriate for the defendant in person to give evidence on his own defense. Now, Oputa GSC, in that Josiah's case I referred to earlier, had this to say, and he said, his lordship said, it is not easy to stand up to cross-examination. It may even be difficult for a trained lawyer to decide on any particular case whether it is safe or unsafe to expose an accused person to the ordeal of cross-examination. Under our system, there is no onus on the accused to prove his innocence. The law presumes him innocent. There is thus no duty on the accused to help the prosecution to prove him guilty. And that is what is happening in many of when we take decisions and they advise the client improperly. Because where the case is not so strong, and you put the defendant in the witness box, the defendant is cross-examined, and the prosecution is able to extract more fact from him than even the fact that is given. So, therefore, the problem will arise. So, it is expected that the defense counsel will help we heed the advice of Oputa GSC quoted above, where the prosecution case is not strong as to secure conviction. It will be unwise to put the defendant in the witness box to face the rigor of cross-examination and expose him to prosecution who may extract damaging evidence through him. So you have to think twice before you advise the client on the first option. On the second option, where there is no strong case against the defendant, to be unwise to put the defendant in the witness box and subject him to cross-examination by the prosecution. Now, the last option that is prescribed under that section and the Constitution is the right to remain silent. Now, the last and the third option open to the defendant, which the defense counsel must explain the implication to the accused or to the defendant, is his right, constitutional right, to remain silent by not giving evidence personally. So he may refuse to give evidence, or he may even refuse not to call any other witnesses. So the right to remain silent is a constitutional right conferred on the defendant by section 36, 35(2), and 36(11) of the Constitution. It is also a statutory right conferred under the Administration of Criminal Justice Act and other Administration of Criminal Justice law of states. Now, the court cannot compel the defendant to give evidence in view of the provision of section 36(1)(11) of the Nigerian Constitution, in that he is at liberty to remain silent at the trial. Well, the defendant is merely a competent witness for himself and not a compellable witness to the prosecution or even the co-defendant. So I refer to some authority there. So the right to remain silent must be properly explained to the defendant by his counsel and the implication of it. Where he is not represented by counsel, the trial judge or the magistrate, in asking the defendant to enter his defense, must explain the options available to him. I refer to some authority where the judgment of lower court were overturned, about 3 or 4 of them, including Ode, on account of failure to explain the 3 options to the defendant. A defendant who is led to keep silent cannot thereafter complain. That's the danger. He cannot thereafter complain that he was denied fair hearing. Because if you decide not to say a word or not to call any witness, then you can't complain thereafter and say that I was denied fair hearing. There are some judicial authority, Supreme Court decision, and which I put in the paper. So when the defendant may be called as a witness, I enumerated areas when it is not advisable to call the defendant as a witness. The defendant, where is reluctant and unwilling to give evidence, you cannot force him as a defense counsel, because that would be against the constitutional provision, that this is subsection 11 of the Constitution. If he's nervous and you know he will not be able to withstand the fire of cross-examination, it is not advisable to put such defendant in the witness box. Where the defendant is an infant or too ill to follow the proceedings to the extent that he may not be able to give intelligent answer to questions, it is not advisable to put the defendant in the witness. where the defendant is incapable of giving any exculpatory or useful evidence in his own defense, it is not advisable to put him in the witness box. Now, the defendant cannot give, where he cannot give any useful rebuttal evidence. So on what basis are you putting him there? So he must be in a position to give a rebuttal evidence for you to put the defendant in the witness box. And then where the story of the defendant is extremely weak, you know he has a very weak case. So by putting him in the witness box, so that the prosecution will destroy him the more. The prosecution has where he has a watertight case, and any attempt to put the defendant in the witness box may further corroborate the case of the prosecution. You advise yourself whether I should put him there. In most cases, my experience have shown that in some cases, lawyers extract, particularly prosecution, extract evidence from the defendant who gave evidence that will further strengthen his case against him. So you have to think twice before you do that. And also the implication of not calling him. Now, after you have decided whether to call the defendant or not, now the issue is order of defense. So how do you do your defense? In which order will you present your case? Generally, the defendant should be called upon before any other witness to give evidence first, once he decides to give evidence, and call other witnesses thereafter. The rationale for this is that while the witnesses are normally kept out of court and out of hearing until they testify, the defendant has the right to be present throughout his trial, and therefore will unfairly has opportunity to listen to the witnesses called by the defendant. If the defendant is not called first, and then have the opportunity to adjust his testimony to accord with the witnesses which he called. And that is what is happening in most cases. I refer to some cases, Supreme Court cases like the Gade's case, Gade and the Queen, Morrison and R, some decision on this. I refer it in that paper. However, even with that practice, there are exceptions. With that practice, if an expert evidence or evidence that is not material, he can give evidence before the defendant give evidence, because there is nothing to extract from such witnesses, because on some technical area like expert evidence and the evidence that are not so crucial, so it can be called first. However, the court had the discretion to depart from it based on those exceptions. Now, the issue of order in which the defendant is to give evidence was raised in Daniel and FRN. It was raised by us. And then we cited the case of Ugedi and the Coin. We cited some other Supreme Court decisions, AK and the state and some other decisions. And the Court of Appeal is of the opinion that they did not follow those Supreme Court decisions. They were of the opinion that if the defendant has the right not to talk, he has the right not to give evidence, on what basis are you going to compel him to give evidence first? So, without considering the rationale behind it, it was held that the defendant is not a compellable witness for the prosecution by virtue of the provision of Section 36(6)(d) of the 1999 Constitution. With respect to the Court of Appeal, their lawsuit misconstrued the section of the Constitution, and the basis for the principle is that the defendant give his evidence first. He listen to other witnesses. He might call in the case, except informal witnesses and witnesses whose testimonies are not in dispute. Now, Section 212 of the Evidence Act still recognizes that while a witness is giving evidence, other subsequent witnesses should go out of court and out of hearing. The basis of this is to allow the witness to give his testimony freely without being influenced by the testimony of witnesses who are testifying before him. I refer to some other decision on it. Now, the Court of Appeal oversight the position of the Constitution that made the defendant not to be a compellable witness. The issue is not whether it's compellable or not a compellable witness. The issue is the order in which he will give evidence. He may decide not to give evidence. He may decide to give evidence. But if he's giving evidence, he is expected. Now, I advise that the defense counsel should, notwithstanding the position taken by the Court of Appeal in Daniel's case, because of the the duty on the trial judge to apportion credit to the testimony of those witnesses. It will be in the mind of the judge that, because a number of cases I've done where the defendants give evidence last, those judges, those judgments, you will see that they don't believe mostly the testimony of the defendant, because they knew that their statement will always depart from the statement, extrajudicial statement they made before. And not only that, they will also look at the testimony of other witnesses they have called and try to modify their defense in line with all those other witnesses. So I will advise that while giving evidence, if you know that the defendant wants to give evidence, in order to enable the defendant to have good credit for his testimony, is to allow him to give evidence first. Now, that is on the order of now, we now come proper to rebuttal evidence. Rebuttal evidence. Rebuttal evidence to be led through the witnesses for the defense. What is rebuttal evidence? I refer to Black's Law Dictionary, which define evidence given, rebuttal evidence as evidence given to expel, to repair, to counteract, to disprove, fact given in evidence. I refer to some other definition also. Rebuttal evidence is a response, but technically, rebuttal evidence is not even the word rebuttal. If you look at the English position, is evidence that the defendant has given, and then he introduced new issue during his own testimony. So where he introduced new issue during his own testimony, now the prosecution will apply to give a rebuttal evidence. Technically, that's the meaning of rebuttal evidence. But in so many judgments, the court also refer to rebuttal evidence as the responses of the defendant to the testimony of prosecution witnesses. So it's not limited to that in our own jurisprudence. But in other jurisdiction, rebuttal evidence is strictly limited to that scope. But we use it in a broader sense in Nigeria. Now, I've explained the rationale. The rationale, rebuttal evidence is a form of evidence that is presented to neutralize, to contradict, to nullify other evidence presented by the adverse party. So rebuttal evidence is restrictive, and I've explained that. Now, it is now firmly settled that if the evidence adduced by the prosecution is tested, scrutinized, accepted, and conclusively points to the defendant as the perpetrator of the crime, it is for the defendant to rebut that the presumption that he committed the offense or cast doubt in the prosecution's case by preponderance of probabilities. So if the prosecution has proved his case beyond reasonable doubt, in the sense we are using rebuttal evidence here, the onus will now shift on the defendant to give a rebuttal evidence to neutralize, to neutralize those evidence given by the defendant, by the prosecution. Thus, the prosecution has, so where the prosecution has established particular issue in his favor, proving the ingredients of the offense, the onus will be on the defendant to give evidence to explain, repair, counteract, or disprove the particular issue. This is a rebuttable presumption of law that a decision will be given on a particular issue in favor of the prosecution who establish it or rely on it unless it is rebutted by the defendant. So authorities are on this point, which I cited in the paper, and I hope everybody will have access to this paper. And then the what his lordship said, GSC on this rebuttal evidence. Now, require rebuttal evidence. I go into specific area where the rebuttal evidence is necessary. Now, where the burden of proof, the body of proving reasonable doubt is on the defendant. That's why the law expects the prosecution to prove his case beyond reasonable doubt. Now, after he has proved his case beyond reasonable doubt, the body now shifts on the defendant to prove reasonable doubt. So his evidence is to show that reasonable doubt, that there is a reasonable doubt in the case. The defendant standing trial is presumed innocent, and I gave all those things. So it is his duty to show reasonable doubt, because I know that my time is going seriously. Now, The second aspect is to give evidence of rebuttal is rebuttal of actus reus, that is the actual act that constitutes the offense, the physical element of the offense. So if the prosecutor has proved that physical element, it is for him to either disprove it or explain his involvement to show that he was not the one who committed the offense. So I explained those. Now, rebuttal of mens rea is also stated there. So if the prosecution has established that the offense was committed knowingly, willfully, purposely, recklessly, negligently, those are the mens rea, the mental element of the offense. It is for you now to give a rebuttal evidence that these offenses, the act was not done knowingly, willfully, purposely, recklessly, negligently. So that is the duty of the defense counsel. Now the defendant's duty to prove his defense. Now it is never it is not the function of the prosecution to establish his own defense, the defense of the defendant. It is for the onus of the defendant to establish his own defense. So I cited a number of authority which only has a duty to prove the guilt of the defendant, and in doing so, he must prove it beyond reasonable doubt. The prosecution is not under any duty to prove the defense of the defendant. I cited the authority of Laia and all Zekwe and Edo. Then exception to presumption of innocence. Now, there are penal enactments that are exempted some person or created an exemption for an offense. The onus of proving those exemption or exception is on the defendant, is not on the prosecution. The onus of proving such exemption or exception is on the defendant to establish that, like there are cases that a civil servant is a person that can be, that the fact that the charge did not say you are a civil servant does not mean that that charge is bad. So if they charge you there, the law presumes that the capacity in which you are charged, you have that capacity. So if you don't have that capacity, it is you that should raise the defense and say, no, I'm not a civil servant. So if the law prescribes that a person who commits this offense must attain that certain age, you can be charged. But it is for the defendant to say, no, I'm not of that age. So that is what section 36(5) of the Constitution is talking about, that the proviso, which was interpreted in so many number of cases, like Daudu, Daihogu, and COP. I cited them in the paper. Now, proof of the property is a proceed of crime. It's similar to that where you need to prove ownership of property, like vehicle, like property, like houses, and or you want to lead evidence as to the proceed of crime. What the prosecution is entitled to do is to show that you acquire that property and to show your income. And the moment you show your income, it is not for him to show that that property is a proceed of crime. It is for you, because it's in the final address, it will just show your income, that you are earning so amount, and you bought property of, you are earning 10,000 naira, and you bought property of 1 million. So there are presumption of law that the law will assume that that property was stolen. So it is the duty of the defense counsel to not look for the evidence where they say it is a proceed of crime, but rather to the insinuation, the presumption of law that that property does not belong to you. It is your duty to lead evidence. And if you see Ogunlana's case, they bought property who was just a clerk and was earning 180,000, and he bought property of several million, bought saloon car, and he was using it. And the Supreme Court said, no, the prosecutor need not to prove that he stole that thing. So there is a presumption because of his salary. So these are the evidence that the defense is required to give. The fact that the defendant is convicted, is in possession of property does not. So I gave all those things. I don't want to dwell too much on this because the paper is comprehensive. I hope it will be made available to people. Evidence of sanity of the defendant is for the defendant to show that it's not, there is a presumption in law that everybody is sane, everybody is of sound mind. So if you are giving evidence, if you are a defendant, and the issue of your sanity comes in. It is your duty to prove it. It is not for the prosecution to establish that sanity. There is that presumption. And there are other presumptions, which I also refer to there. The presumption of last sin. The presumption of last sin, that if a disease does disappear, and that disease was found in your house last, or we accompany you in a car, just like in Somalia and the States. So the presumption of law is that the man who was with him last was the one who killed him. So if at the end of that, the only thing they saw is the corpse of the man, so the presumption of law is that the last person who was with the deceased is the one who killed him. So he's the one who will give rebuttal evidence. So there are other presumption of accident. So where somebody is somebody and ran away, and then they couldn't get the driver, but they know the number. So the presumption is that the owner of the car who hits the man and kill him. So he has to establish that he was not the one who drove the car at that particular time, or that because the number of his car, the registration of his number show ownership. So the presumption is that he was the one who committed the offense with that vehicle. So the onus is on him. Now, presumption of natural and probable consequences. So when you do something, it is presumed that you know the consequence. There's one case that is in the case of Isha Sally in 1988, a woman who was sleeping with the 4 children in the house, and that woman was he woke up the four children, brought them out, and set the house ablaze, and locked the key of the house, and the husband died in that inferno. So you guys, no, I did not kill you. Say no, you have to explain that who locked the key to the houses, who set that place on fire. So there is presumption that the natural consequences of what he has done resulted in the death of her husband. So there are some other cases which I put there. Then I've explained the ownership of vehicle. Now, standard proof by defendant, where the law requires defendant to give evidence or to prove a fact. The burden of proof on the defendant is not proven beyond reasonable doubt. Is on the probability, just like in civil cases. So, but he has to meet those basic things. Now, the mode, then we now briefly, so that before my time ends, because I'm mindful of my time, the front loading of documents, the mode of and procedure of tendering documents. The mode and procedure of tendering documents are regulated by the Criminal Procedure applicable to each court, and also the provision of the Evidence Act. The criminal procedure prescribes the mode in which the documents are to be tendered or brought before the court before you tender them. And then the provision of Evidence Act regulates the admissibility of those documents. So I try to explain the proof of evidence, how you need to have access to it, and what you need to do with the proof of evidence, and that the fact that it must be made available. What is the proof of evidence? Because all of us, we always think proof of evidence is all the documents you want to tender and what are to be front-loaded. I explained those things, and you consider the rights of the defendant that he should be given adequate time and facility. The decision of the Supreme Court in Okoye and what the Supreme Court says, that all the material must be, whether it's magistrate court, whether it is high court, all the material must be made available to the defendant, and how the Okoye's case was reviewed later in Nweke's case, and then what the Supreme Court said, particularly in the last decision of Madu Kwevu and the state. Now, I explained that the area that is strange to us is probably the area of discovery or disclosure. Now, in Nigeria, the prosecution is able to have it easy because we have that impression that the practice direction issued by each head of court are against the defendant. The defense counsel have that impression that how would the defendant front load documents? How would the defendant disclose his witnesses? How would the defendant do this? Whereas the process of discovery that the defendant is entitled to pry into the record of the prosecution. It is process of discovery or disclosure that is able to know the unused material that the prosecution has. There may be exculpatory evidence in possession of the defendant and or the prosecution, which they will not bring forward. It is through this process of discovery that they will explain to the court that the defendant will request and have access to those unused material. So this unused material is an opportunity for the defendant to have access to other prospective witnesses who made statement that their statement were not front-loaded. The document brought by them, it is through the process of discovery that they're supposed to have that. But we blindly reject those practice direction, particularly the practice direction of the High Court of Federal Capital Territory 2017 by his order 5. The requirement there, with how we should agree, the evidence to tender, area of dispute, and all those things. But we oppose it because we don't know the benefit of that is inherent in those proceedings. So if we know the benefit, we will not be opposing all those things because we help us to actually defend the defendant. Now, I refer to the practice direction, the law in England, and I quoted the section 6 of the criminal procedure in England that allows the defendant to even front-load their evidence and present their cases before the court. So, and decision of the Court of Appeal in England on it, there's nothing unconstitutional about it. There's nothing improper about it. So, we are not using the process of discovery in our defenses. And that is why we are having so much problem on that. Now, I just talk about the subpoena, witness summons, how it should be done, the difference between various types of subpoena, the 3 types of subpoena that were mentioned, and then for the one that even if you do stecum, you give a subpoena do stecum, and you put that witness in the witness box. So, and then brought the document. You have converted that subpoena do stecum to subpoena testificandum, because once he is in the witness box and is sworn and he tendered that document, he has become a witness, which must be cross-examined. But if he just to produce document, do stecum, he just bring the document, drop it in court and go, and he will not be liable to cross-examination. So I explained the difference of those 3 methods. Then the summons that is normally used in criminal cases, and then the one that you cannot issue at the magistrate court. I explained that also. Now, extrajudicial statement, which is tending of those extrajudicial statements. You know, as a defense counsel, you are interested in the extrajudicial statement made by the potential witness for the prosecution. Now, the position of law has always been, there are about more than 50 cases on it, that the extrajudicial statement of a witness in a criminal trial is inadmissible as evidence for either the prosecution or the defense. So you cannot tender it, you cannot use it except for the purpose of cross-examination. I refer to some of the authority where it is stated. Now, the recent development by the Supreme Court, which I put, is the case of State and Nwafo in 2021. Now, the position of the Supreme Court in 2021 is that the statement from extrajudicial statement by prosecution witnesses can be tendered by the prosecution in order to corroborate, to support the testimony of those witnesses. So, which is very new. So it's new to me. The argument just said usually the prosecutor does not tender evidence, the extrajudicial statement of his witness made at the trial stage as part of this case. The witness having testified, the prosecution may decide not to tender it, but now it can tender because in view of the position of Section 237 of the Evidence Act, that allow the statement made previously to be admitted in order to support the testimony of that witness. So it's a clear departure from the old rule. Then I talk about the computer-generated documents, an area that every one of us and the training has also covered, the computer-generated documents. But I just say a few words in that. Now, I will end with the professional duty of defense counsel. Now, the Order Rule 37 rule and Rule 38 of the Rules of Professional Conduct of Legal Practitioner prescribe the basic conduct for a lawyer engaged to defend a defendant in a criminal matter. The basic and primary duty of the defense counsel under the rules are many, and if you look at them, the defense counsel shall exert himself by all fair and honorable means to prove before the court all matters that are necessary in the interest of justice. So you see, all the things we have been talking about, evidence to lead, advice to give to the defendant, they are all covered by the rules of our professional conduct. He shall not stand or offer to stand bail for a person to whom is representing. That is where I am taken aback. I went to a law enforcement agency and I saw heap of our certificates, court to bar certificates in the law enforcement agency's office, where lawyers use their original court certificate as a surety for bail. So it is the trend in which the rate at which we are going. I think is an area that we need to warn ourselves. It is against the rule of professional conduct that you stand or offer to stand bail for a person for whom you are to represent or appear for. Now, in murder trial, the defense counsel is, once he enters, is deemed to have been sufficiently brief and he must conduct the case. He cannot withdraw. There is a decision where a lawyer was not paid and the High Court, the trial court revoked the bail of the lawyer of the defendant, and the Court of Appeal is saying that no, the High Court should not be a recovery agency for a lawyer, and then you don't deny the right of the defendant merely because fees were not paid. Now, when the defendant disclosed facts which clearly are credible and credibly show his guilt, the lawyer shall not present any evidence inconsistent with those facts. Now, I have seen, my experience in recent time is that where conventional statement is made, the defendant even come to court. Our police will say, no, say you did not do it. So it is not right. So I think it's both sides. It's both the prosecution and the defense. In some cases, the prosecution first gets conventional statement at all costs. So we should try and change all these things, and follow the rules of professional conduct. Thank you very much. In conclusion, with the above observation and comment, I hope that when you read this paper, you'll be able to see that there are some issues that are raised here that I think we can rub mind on and then improve our practice. Thank you very much. Hello.
Yes. Thank you very much, Mr. Jacobs, SAN, for a well-researched and well-delivered lecture. It was quite enlightening, sir. You finished just a few minutes of 1 hour mark. We don't want you to leave, sir, without answering 1 or 2 questions. So we'll just ask you 2 questions that we're going to pick randomly from the portal. The first question, sir, is one of our colleagues would like to know what happens when the defendant is the only defense witness and he needs to testify but is incapable of giving evidence due to instability or incoherence. What does the judge do in that kind of situation? The emphasis being that there's only one defendant. I think this colleague is referring to probably a personal case that he has. Lensu, you need to unmute yourself, sir.
Yes, please, I can't hear you. Where, sir?
Okay, I'm going to repeat the question, sir.
Yes.
The question is, what happens in a situation where a defendant is the only defense witness and he needs to testify, but is incapable of giving evidence due to instability or errors? What options are available to the judge in that situation?
I think the first thing the judge should do, it's not the judge that takes the decision. It's his counsel that will take decision whether we give evidence or not, if it's represented by counsel. In fact, the judge will not be involved once you are represented by counsel. So the decision whether to give evidence is that of his counsel. Now, and where it's not coherent, where it's not stable. So I will advise that first, let him give evidence in the language that we understand best. So, because if you are not coherent in English, you may do better if you are a Yoruba man or an Igbo man to speak better when you speak with your own local language. So it should be comfortable enough. Now, other options that are available is that he can apply that he give evidence because he can give evidence through video recording, through video link. Is possible under an act now to apply to court. He can be in the comfort of his home and then apply to court. Let my witness, on account of so number of reasons, let my witness give evidence by through video link. And he will arrange all those things. So the man will be at home and then give his evidence. So which it will be in more environment, may probably be better in terms of being coherent. The other option that the window that have been opening up now is the area of affidavit. You know, the area of affidavit, the Administration of Criminal Justice Act only allows affidavit evidence to be given in an area that is not in dispute. So, but in other jurisdictions, it should be allowed to make a deposition. And then after making the deposition, it can now subject him to cross-examination. So the option is on. But if he knows that this defendant will not be coherent, will be very weak in the testing, in the witness box, it is not advisable to call him. It is not advisable being sworn on oath without being cross-examined also. So that's an option. But as I said in my main lecture, is that the judge will apportion credit to his testimony. So that is the problem there.
Thank you very much, Daniel Silk. Your perspectives are quite practical. I'm sure that the person who asked that question has gained one thing or the other. We'll just ask you one final question before we go to the next speaker, sir. Somebody would like to know what is the degree of proof required where he's not reporting, but is required to prove his innocence under the statutory exceptions to the presumption of innocence. Is it still reasonable doubt or beyond reasonable doubt? I'll repeat the question, sir. What is the degree of proof required where a defendant is not reporting, but is required to prove his innocence under the statutory exceptions to the presumption of innocence? Is it still reasonable doubt or beyond reasonable doubt?
No, it's not. As I stated in the case of Daudu and FRN I cited in the paper, it is not. It's just proof, just like in civil cases for the defendant. So the defendant will not be required to prove beyond reasonable doubt areas where is expected to prove facts in a criminal matter. The proving beyond reasonable doubt under Section 135 of the Evidence Act is limited to the prosecution and not the defendant.
Thank you very much, Lionel. At this point, we're just going to let you wait a little while. I'm hoping that you will be here till the end of the session. Hopefully, if we have a little bit more time at the end of the session, we might come back to you with further questions. At this point, sir, we're going to go to the next segment of today's webinar. I would, at this point, like to introduce the next speaker to our colleagues. The next speaker is Mr. Raphael, who is retired assistant superintendent of police, a forensic document examiner, and was officer in charge of the document unit of the Nigerian police from October 2007 to 1st April 2019. He gained practical experience in forensic examination of documents by virtue of his position mentioned above, and asked for more training in the analysis of documents and their scientific identifications in addition to other qualifications. He has attended several trainings and received trainings in several areas of the law, which are quite extensive. I'm going to skip that portion of your profile, sir. During his active service with the Forensic Service Laboratory of the Nigerian Police Force, headquarters, D Department, FCID, Alagmo, Ikoyi, Lagos, he trained officers of the Nigerian police and lectured visiting students from higher institutions, the Nigerian Army, the Nigerian Air Force, the Nigerian Navy, and private institutions. He is a consultant to the Nigerian Police and Directorate of Public Prosecution. In his retirement, he is the principal at Master Pattern Forensic Services Limited, a company involved primarily in the examination of comparison of handwriting, signature, transcripts, rubber stamps, impressions, chart documents, secret writing, watermarks, wire marks, texture of documents, and their scientific identifications. By virtue of his academic qualifications, forensic training, and work experience, he is an expert in forensic examination of signatures, handwriting, typescripts, rubber stamp impressions, seals, secret writings, wire marks, etc. He has given evidence as an expert in several courts in Nigeria and Africa in over 2,000 cases over the years. Some of the cases which he has given evidence as an expert forensic document examiner in criminal and civil cases are all replete in the law reports that we have around. Aside from the regular court, he has also given evidence in various election petition tribunals. Ladies and gentlemen, please join me in welcoming our second speaker for today, Mr. Raphael Omuzuligbo. Sir Omuzuligbo, you have the floor, sir. You need to unmute yourself, sir. You need to, you're muted, sir. You need to unmute yourself on the screen. There's a mute button that you need to click on. Can you please kindly unmute him?
Okay. Can you hear me, sir?
You're welcome, sir. I hear you now.
Yes,
Thank
sir.
you very much.
I
You're
said,
welcome, sir.
Good afternoon, my lords, learned silk, and other distinguished legal practitioners. My name is Raphael Omuzuligbo, an assistant superintendent of police, retired, and a forensic document examiner. Like you have already introduced, mentioned all what are supposed to concerning the qualification. I will start by saying that I'm glad to be in your midst to contribute to the criminal trial and civil litigation in Nigeria from our past experience. So let me start by not wasting your time. I'll first of all say, who is this forensic document examiner? Yes, sir. Forensic document examiner. The forensic, can I continue, sir?
Yes.
Okay. Okay.
This slide is being displayed.
Yes, you can continue, sir. We can hear you, sir. Please continue.
Oh, okay, sir. Forensic document examiner is an expert who was trained on how to analyze the documents and their scientific identification. The forensic document examiner also, after analysis, will go to court or wherever they call him concerning what he has analyzed to contribute to the trial. That is the forensic document examiner. The concerning the other aspect of experts is in his own contribution to the trials. the forensic document examiner is the one who can tell a lawyer or the court concerning the aspect of a disputed document, that is the document in question. You will agree with me that it's not all the area that the lawyer knows. There are certain things that expert will aid him to achieve his defense or prosecution. My lords, what I'm trying to say, let me continue with the further headings that I tabulated there. I talk about, from my past experience, I was a case concerning a suspect. Police obtained a statement, first statement from the suspect. But later, when they brought the suspect to the court, it happened that the police brought another statement purported to have been made by that suspect. So this case was sent to me for me to look at the handwriting on the body of the first statement and the handwriting on the body of the second statement, and also to look at the recorded by. That's where the person who recorded the statement or whereabout. So by the time I look at these two documents, I discovered that the first statement, the body containing the writing, is different from the writer of that particular one. It's different from the second statement. So what I'm trying to say is that lawyers who are handling cases in the court, whenever such thing comes, if your client is disputing over, you need an expert who will assist you. Experts to look at these documents, you need an expert. Experts' witness is very important in all your dealings concerning trials, both criminal and civil litigation. If you look at, when you come to the area of question document, talk of question document, the council is supposed to look at all the area. If you will talk about the document that has this letter-headed paper, and you are contesting over only the signature, what of that, the writings, the printout of that letterhead? You should look at that area also. Compare it. You get the original letterhead of that company. You supply it to the experts who will now help you to examine, compare that printout, that letterhead with the original. Because from my past experience, I've analyzed documents that when you look at just pictorial appearance of that letterhead with the fake one, with the original one, we think that they are the same. But when I look at this and examine them closely, I discovered that that fake one lacks certain arrangements. And the character of the printout, the character of the letters differ. So I was able to prove that from that letterhead, the letters there, they are not the same with the original. Then another area again I will touch is concerning obtaining a specimen for purpose of analysis, what we want to give experts to conduct his analysis on. So the lawyer should obtain specimen. He can obtain fresh specimen, or you look for standard, that is, we'll call it a previous writing or signature or document that that person made, you use it and add, get enough samples and give the expert so that the expert can be able to decipher, to look at and distinguish or distinguish the one document from another. Check the natural variation. And also, by checking the natural variation, you will see whether it is that person who that is on a previous writing or document that was supplied, signed or wrote the document. So the lawyer who is handling all these cases that I want to send to the expert so that the expert will assist him. It is the expert that will look at these documents and bring out something that will help him in the trial. So there's what we call especially this master pattern or inherent features or traits of every individual. Every individual. Two persons cannot have these inherent features. It is this from these inherent features that experts look at. Expert is not looking at the pictorial appearance because human being cannot write exactly, that is for the pictorial appearance, exactly the same, because if you compare when you sit down to write or sign, it differs from when you stand up and sign or write. But these master pattern or inherent features remain unaltered because that is from where the basic. When you started learning how to write, you have already deposited that formation in your brain. So whenever you are called to write, that is the time it comes from your brain to your vein, your finger. So the way Mr. A writes his letter T, B differ, D or C or so forth differ. So I just mentioned this one just to buttress my point that experts witness assist the lawyer or the lawyer handle the counsel handling the case to prove his case in the court. Then another one I want to mention again. Another one I want to mention again is consigning here of documents. From my experience, I've seen that some lawyers, in sending documents to the experts, their markings, if they want to draw attention of the experts to the actual place, maybe signature or handwriting that they want the experts to analyze, they will asterisk and they touch that signature. It is not good. It is not good. It affects the signature, the letters, the strokes. So if whenever you want to draw attention of the experts, you give gap. If you want to use the arrow, you can use the arrow, but don't touch that signature that you want the expert to analyze. Handle your documents with care. And also, do not tell the expert a long story. Long story. Some of the counsels used to write even for 10 pages, telling story. Expert does not need that. What expert needs is what you want him to analyze. Go straight. Once after your preamble, go straight and say your second paragraph will now be talking of will request you to examine and compare. So this and that. And ascertain whether they were signed by one person or not. So you need not to tell an expert story, all the story, what happened in the case. So the next one that I'm going to take is on the area of examination and comparison. Examination and comparison, what is examination? Examination means examining, inspecting, analyzing, investigating. Comparison means after you have inspected or verified certain area, then with another side of it, you bring them together side by side. You start to look at from initial stroke, the letters, the media, the terminal. It is when you now show them together, that is when you can be able to ascertain or determine whether these signatures were signed by one or 10 persons or not. And secondly, in demonstrating or illustrating in the court, if the expert bring his comparative table or chart analysis, some will now put arrow 1. You are the one now illustrating, telling the court, this stroke, arrow 1, is like this. You compare it with arrow 1 on the other side. That is how you can be able to convince the court that this arrow 1 here, that letter arrowed 1 on A, signature A, and the arrow 1 on signature B, they are the same thing. They are from the same person. Instead, some will make arrow 1 on signature mark A. Then on the signature mark B, they leave it, they put 2. It does not give a good sense. It does not. A lawyer should ask every expert question concerning his work, concerning his comparative table. You ask question, not to just leave or somebody will just say, he's afraid, this and that. Ask question. When you ask expert question, more things will come out. It will help your case. It will help your case. So I think, I don't know whether I've exhausted what I wanted to. I don't have much now. Thank you, my Lord.
Thank you very much, sir.
Yes.
Thank you for your time and for sharing of yourself. We would go to the questions now. Hopefully, I'm going to, I know you are going to round up so quickly. I'm going to see whether there are questions in the questions room specifically for you. There are a lot of questions there, but it appears that some of those questions are for Mr. Rotimi Jacobs. But let me see whether there are questions for you, sir. You just give me a second.
Okay, sir.
Now, hello, sir. Somebody would like to know whether there are trainings, professional trainings with certifications on becoming a certified or professional forensic document examiner. Did you hear me, sir?
Yes, sir.
I have a few questions for you. I'm just going to repeat the first one.
Oh, okay, sir.
The first question, I'm going to repeat. Our colleague would like to know whether there are trainings available on becoming a certified or professional forensic document examiner.
There are training, not, it depends on the institute handling it, where you can enroll and pass through their training. After the training, they issue you certificates. So that is that is the training on ground. There are so many institutes now that are conducting training. Once you contact them, they will tell you what it takes. So you go through the training. When you complete your training period, they issue you certificates. That is how you can become a qualified forensic expert.
Thank you very much, sir. I don't think that there are other questions for you at this point, but if we do have questions for you, we'll come back to you. Lana Silk, Mr. Rotimi Jacobs, sir, there are a few questions for you. I hope you're happy to take them now, sir.
Yeah.
Thank you very much. James Amendi would like to know whether a defendant can bring an application challenging the jurisdiction of the court after the prosecution has closed his case.
Well, the issue of jurisdiction is as it is known to all of us, can be raised at any time, even at the final address. So it's a threshold issue that can be raised at any time. Now, there is this contention now that whether you can raise it upon service of charge on you before plea is taken, or whether the court should deliver decision on it based on the Administration of Criminal Justice Act, Section 396, so Section 4, and some other section also there in ACTA. The question, because if we look at the case of that investment, the Supreme Court is saying that even the issue of jurisdiction, but there are other conflicting decisions now that DESRA, the case of DESRA and FRN, the Supreme Court is saying that now you can raise it, but to be decided at the final judgment. But there are other decisions now, particularly at the Court of Appeal, to the fact that the issue of jurisdiction can be raised at any time, and that the court has a duty to decide it before it proceeds further. And if you look at Mohammed and FRN, Begore and FRN, the Supreme Court actually took the issue of territorial jurisdiction or the Federal High Court at the Supreme Court, and the Supreme Court resolved them after the no case submission was made in those cases. So the issue of jurisdiction can be raised at any time, and then there should be no law that will prohibit a party from raising the issue of jurisdiction. But there are so many issues of jurisdiction that if jurisdiction has to the judicial power of the court to determine the case, not on other grounds like other issues that the charge is not properly couched and all those things, and then link it to jurisdiction. But true jurisdiction issue can be raised at any time, and the court we have a duty to resolve it. Thank you.
Thank you very much, sir. There's another question here for you, sir. What I've noticed from the questions and their trade is that most of them don't flow directly from today's topic. But I do not blame our colleagues. It's not every day that they get to see you and benefit from your wealth of knowledge. So some of these questions do not flow directly from today's topic, but I'm certain that you'll be able to answer this. Somebody would like to know whether a prosecutor can tender evidence that was not in the proof of evidence. Whether a prosecutor may be allowed to tender evidence that was not in the proof of evidence in the course of trial.
Well, the purpose of Section 379 that require front-loading of cases is to enable the defendant to have full knowledge of the case that is against him and to be able to prepare for it. Now, it's for the purpose of fair hearing. It's not simply on admissibility of that as evidence. Now, if you did not oppose it, the court will we admit it. But if we oppose it, the only thing the judges can do in this circumstance is to order the prosecution to allow the document to be brought to the attention of the defense and give time to respond to it and before they tender it. So it does not govern admissibility. It's just the issue of fair hearing that you are able to prepare for your defense. So it can be tendered if you don't oppose it. But if you oppose it, it cannot be refused. The admissibility of that cannot be refused on the ground that it's not in the pool of evidence. Kwashi's case and the state, I think it's part 375 or so. So the fact that the document is not in the pool of evidence is not render it inadmissible, and some other decision to that effect. But the court, it will lead to adjournment, and the court will adjourn to enable you to study the document and then tender the document. Thank you.
Thank you very much, Lionel Silk. Further questions here for you, sir. A colleague would like to know whether a judge can admit evidence in criminal trials without the prosecution complying strictly with provisions of Section 84 of the Evidence Act, which I presume is on certification of electronically generated evidence.
I know. Well, you know, some of our colleagues ask questions that that may not. You need to know what's really transpired before admitting those documents. Now, if you look at Daudu and FRN, the document was it was on prosecution of a local government chairman in Kogi State. Now, EFCC obtained documents from the banks. So, and when they got those documents, there were no certificates that the statement of account. There were no certificates. There were nothing. Like they did not comply with Section 84. Now, they sought to tender it, and the Supreme Court said there was nothing wrong with its admission. Now, there is a case recently by the Court of Appeal, Stanbic IBTC Bank, and one case like that, where the court is saying now, the position of the Court of Appeal now is that when this document you are seeking to tender is not generated through your own computer, you don't need to comply with Section 84. Like, you are a customer of the bank. You went to the bank, you apply for statement of account, and then you seek to tender it. The document that was given to you by a third party. So your computer did not produce it. Now the need to comply with Section 84 will not arise in that case. So there are exceptions. So a judicial exception now to that Section 84. That's why I said you need to know what really transpired. Because if that document is produced through a computer belonging to a third party, you can't ask him to comply with Section 84. So the court, in certain circumstances, can admit documents that are not produced by the person who is seeking to tender it through his own computer, but by a third party.
Thank you very much, sir. I'm just going to ask you another question.
That case is Stanbic IBTC Bank and Long-Term Global Capital Limited. Is in 2021. Stanbic IBTC Bank and Long-Term Global Capital Limited. So read it. You will see that they can tender it.
Thank you very much, Lionel Silk.
Thank you.
Another question which I think you probably have answered, or one of our earlier speakers have answered, but it's possible that this particular colleague of ours was not there when this issue was dealt with. Our colleague would like to know whether the prosecution can call a witness whose statement was not recorded at the police station. Whether the prosecution can call a witness whose statement was not recorded at the police station.
Okay. Yes. Yes, there are procedures to that. It is expected that the prosecution should, a witness, a third party that you are being called as a witness, it's expected that the prosecution will make the police to invite him to make his extrajudicial statement and call him. But there are exceptions. Where a witness did not record his statement, you can obtain a subpoena for him. You can issue witness summons, and if he gives evidence, you don't need to front load whatever he says to give evidence. So there's an exception to this procedure of subpoena. This procedure of summoning is an exception to the proof of evidence that you must front load the statement of the potential witness. So if he's not called and they later stumble on him, it can be summoned to do that. But in most cases, I will ask them to, before I call him, if I didn't want to subpoena him, I will ask them to go and obtain his statement. The time they obtain the statement is not does not affect is not material to the testimony that is coming to give, provided that the evidence is given is what transpired before the charge was filed. So that is the position on that.
Thank you very much. Our colleague, his name is Abdurrahman Yusuf, would like to know what probative value can be ascribed to the testimony of a witness who observed another witness in the case, in the criminal case, give evidence before he was called. He didn't say it, but this is basically something akin to what we observe when trials are about to call, when they say witnesses who are going to give evidence should go out of court and out of hearing. He says in an instance where that kind of infraction happens, what's the probative value of the witness, the statement of the evidence of such a witness who had observed earlier proceedings or testimonies?
First, Section 212 of the Evidence Act that prescribed that did not say that witness is not competent to give evidence after observing the proceeding. He can still, the court can still believe him if the judge watched his demeanor and discover. So it will not defeat the testimony is given, but the court will just be careful for because of he observed the testimony of other witnesses. So it's just the credit that the court may give to the weight that the court may give to his testimony, but that will not defeat his evidence before the court. But the judge who watched the demeanor of that witness is in a better position to apportion credit to his testimony, and then he may believe it, him, or may disbelieve him. So depending on the demeanor that the court watched, is purely at the discretion of the court.
Thank you very much, sir. At this point, I'm going to go back to Mr. Owunzolibo. Questions that have come in for you, sir.
Yes, sir.
So, Stephanie Ikonda Ojekere would like to know, in a case where an employee's signature was forged to acknowledge a termination, what are the chances of the employee proving a case, especially where there is a witness testifying against her? Please, I apologize for the way some of these questions are couched. I'm reading them directly the way they are. I've been couching up, and from the way they're couched, it will appear that our colleagues are dealing with personal situations. So I'll just repeat this one so that you get proper context. She would like to know what the chances of an employee is where her signature was forged, acknowledging that acknowledging her termination. What are the chances of proving her case where there's a witness testifying against her? I'm not sure whether that's very clear to you. It's not really clear to me.
Well, my answer to this is that the chances of that person is that her lawyer or his lawyer should seek the assistance of the forensic document examiner by providing previous document that particular person signed and a fresh specimen from that person. Once you supply this to the experts to look at the signatures, the one question and the one on the undisputed. So when they report, the experts, even if the expert send this document to, look at these signatures and say that they were signed by one person. It can still go further, look for another expert. It can still go further, look for another expert to also look at it again. If actually the person is saying that she or he didn't sign or whatever, you know, in this, from my past experience, I discovered that some people can do something because of intimidation, because of so many things. They will come behind and say, I apologize, so see what happened. My life is in danger, this and that. So the chances of that particular person is to go through the expert. It is the only expert who can now say, this and this, they are not the same. And make sure that you provide enough signature or enough documents to compare with that one in dispute. If actually that person didn't sign, he will see it during the comparison. He will watch the strokes. He will watch the letters. That is why I earlier mentioned something concerning this pictorial appearance. The pictorial appearance deceives people. When you mention something concerning fingerprints, people say it's unique. Handwriting or signature is unique also. Because why I say it's unique, that particular trait, you can make an example by yourself. Just sign your signature, even 5 places, 7 places, or whatever. Cool down and look at inside. You will look at, there are certain things you will see there that another person cannot have. So there are chances for that particular person. Go further, even if that expert give you wrong, this thing that is not, I cannot call it wrong, something that you are not satisfied with. Go to another expert. To another expert.
Can I say something on that question?
Yes, yes, sir.
That's okay. Yes.
Hello? Yes. What I see is that I think I will advise that person to do his petition to the appropriate authority, maybe to the police, to allege forgery, and let there be proper investigation of that case. Now, it is not, you may call two expert evidence, and you may get different results. So our expert that is talking, he agree with me that in most cases like this, it is the person who paid that get the best results. So I will, and the court is not bound to accept the expert opinion. In fact, they are ready now to accept the expert opinion. Now, if this case is properly investigated, you can even call the persons, the HR in that company who produce the document, to tell them the origin of that document and extract more information from the company and from the suspect too. So, because as he said, our expert, even my own signature cannot be, I can't sign the same signature twice. So it's always unique. The one you signed today may not be the same yesterday. So the one you signed yesterday. So I think the proper investigation is needed. The judge himself can compare the evidence, the signature of this person with the signature of the with other signature that the man has. So it's not this expert evidence is not in all cases that is mandatory. The judge himself can do so. So I think he should report the matter to the police or to the appropriate authority and let there be proper investigation of the case.
Thank you very much, Lionel Silk, for that perspective. it was as if you had seen the next question that I was about to ask Mr. Onzulibo. Our colleague Obi Anoye would like to know, how do you make provisions for natural variations in somebody's handwriting so that you don't lead to a wrong conclusion? Because I am aware that people have natural variations in their handwritings. Our forensic experts, basically what he's asking is whether forensic experts have special trainings and indices to determine what a natural variation in somebody's handwriting is, so that it doesn't lead to wrong conclusions. So, Mr. Onzulibo, that question is for you, sir.
Okay, sir. So the forensic expert being the one trained on how to fish out traits, that is the inherent features, distinguishing between two people or more than. Natural variation is allowed in the field of handwriting. This is because of this human labor. Human being is not expected to function like exactness of printer, typewriter, or machine. So that's why when I stated earlier, talking about when you compare your signature sitting, walking, or whatever, you will see pictorial changes. But what identifies that person is this inherent features. That's why I say, if you go down now to look at your own signature, if, no matter, even apart from that changes, the pictorial appearance, you will see that thing, how you dot your I, the stem of your T, the crossing bar, it differs from Mr. B. All those characters identifies you wherever you go. The size identifies you wherever you go. So back to this natural variation. Natural variation means maybe in the case you are doing something in writing or this and that, with the speed, one of your T or A, just the way you push your biro or something just happened, it shifts. So for the experts to determine some of the changes in the handwriting of that particular person or the signature, you will get more signatures. That's why I say if they want to supply to the expert, they get like more than one or two. So from there, the expert now will look at that stroke that changed in the disputed one. Check all the three signatures, authentic signature. It will check all the strokes, formations of the authentic. Compare it with the disputed. This is where we'll find out the natural, this is where the natural variation comes. In addition, when you stand to sign your signature, and when you sit, you will see changes. All those ones are also natural variation. It will check other aspects of the formation of that signature to know actually whether actually this person is the owner of this signature or not. That threat will still betray that person. There's nothing, as far as you are signing the same pattern of signature, unless you change your pattern. As far as you are signing the same pattern of signature, you will still execute it. You will still exhibit that your threat there. That is where the expert look at. Expert is not just when you give him a signature or handwriting, he just enter, conclude. He will look at those master patterns, all those areas, to distinguish that particular writer or signatory from the other. So that is the answer to that. Natural variation is allowed in the field of handwriting.
Thank you very much, sir. Learned Silk, this particular question was addressed to you, and it relates to signatures as well. But our colleague who asked it specifically said we should please ask you to please volunteer and answer to this question, even though I think you've mentioned something in passing about it. But for completeness, I'll repeat it. He wants to know what happens when the court takes a sample signature during cross-examination. Is the court bound after taking such a sample signature to consult an expert, or the court has the liberty to compare it and make a determination on its own?
It's in the Evidence Act. Yes.
Hello, sir.
Yes, I'm hearing you. There's a specific provision in the Evidence Act that permits the court to compare signature of disputing signature and make his own view about the signature. There is a specific provision in the Evidence Act. So the court is not even bound by the opinion offered by the expert. So the court's on his own, and there are judicial authorities to that effect, on his own, compare the signatures and make his own findings and find it on it. So the court is not bound by whatever the expert opinion has done. We have done several cases where the judges rejected the opinion of expert evidence, and then on his own compare the documents, and it's a good practice.
Thank you very much, Daniel Silk. I don't know who's going to answer this question, but I'll put it out there. Now, Blessing Ewu Gary says that with digital trends and with the advent of e-signatures that we have now with people signing documents electronically, it says, do you have anything to share with us on disputes related to e-signatures? How do you prove that someone did not actually authorize the use of his digital signature on a document? Mr. Hunziliwo, you want to answer that question, sir?
Okay. My answer is that as far as examination and comparison is concerned, more of that documents electronically produced should give an expert with the one in dispute. He will look at it. He will look at it. It is by examination and comparison. That is from where you can decipher which one is authentic. So without even analysis, that is examination and comparison of the two things, there's no way you can just come out. The person will continue to say, I didn't sign, I didn't authorize. So based on one document, how are you going to? The person is saying,
I wanted to clarify that question. The question, sir, is that where somebody says he's not contesting the fact that it is his signature. It's an e-signature. It is his signature, but he's saying that he was not the one who appended it because somebody else might have put his e-signature on a document. The question is whether you have any experience with this kind of thing, because this is likely to happen in the future, because that is the trend now. A lot of people now sign their documents electronically. It's their signature. But the question here is, I mean, do you have any experience with disputes of this nature, and what's the best way to resolve such disputes? Because it's not a function of the signatures. You can't compare them because it's the same. It's the circumstances under which they were used that becomes an issue for dispute.
The best way to go about it is to make a report.
Mayowa, if I may to take this aspect of the. Hello, Mayowa.
I can hear you, Mr. Onyeke. You want Mr. Jacobs to speak to it, or you want to speak to it directly, sir?
No, I wanted to share an experience.
Please go ahead, sir.
Yes, there was a particular case that we did some time ago that
I'm not hearing anything.
Hello, can you hear me? Hello? Hello? Hello?
Yes, I can hear you now.
Okay, good. I said there was a particular case that we did that falls on all fours with that question. So that's why I offered to just share my experience. There was a case that we did that the chairman of the company usually applies his signature electronically. So the question was, there was a particular document that the other side wanted to rely on to prove that he signed a document, and he was contesting that no, though he applies his signature electronically, he always knows the document that it is to be applied to. And this was not one of those documents. In other words, he did not authorize his signature to be applied to this document, which seems to be the bone of contention. So I think in that case, what we tried to do was to prove that it could not have been him who authorized it by relying on facts. The facts we relied on were facts concerning where he was and the circumstances of signing those documents to prove that there was no way his consent would have been obtained in applying his signature electronically there, because there was nothing to contest with respect to the master pattern of the signatures. It's an electronically applied signature. It was the factual situation leading to his application on the document that we were now contesting. So what we now asked the court to order, there was a motion we filed where we asked the court to order the bank, it was a bank that was contending that the signature was by the man, to produce all the documents that had the man's signature in that transaction, so that we could bring them to court and bring the factual situation involving the fact that the man was not even available to even have given his consent. But of course, they contested it, and somewhere along the line, the matter went into some settlement. So we could not get a judicial resolution that would have given us one thing or the other. But it's an interesting situation in the sense that we are likely to see more of such things coming up in the future. So I just thought to share my own view concerning this fact that it's already happening. And usually the best way to deal with it is to look at the facts of each particular case and how those signatures were applied. Because if the man, like I said before, insists that before his signature is applied, there's usually some kind of paperwork that goes on that make it clear that it's aware it's going to be applied. And those procedures were not followed. Obviously, once he lays the foundation, a proper factual foundation for it, it should help the court reach a conclusion as to whether, though it is his signature, he had this consent in applying and in the application to that document. Thank you.
Thank you very much, Mr. Onyeke, for sharing your experience. Like you said, we're likely going to have situations like this going into the future. Hopefully, we will begin to see cases and jurisprudence develop around situations of this nature. Unfortunately, we've run out of time. So at this point, I'm constrained to thank the members of the faculty who have contributed today, and to also thank members of the faculty who have consistently joined in and participated in these sessions as we proceed. Thank you very much, Lanet Silk, Mr. Rotimi Jacobs, for giving of your time and yourself. We really, really appreciate you on behalf of the entire ICLE committee and the chairman. We express our profound thanks to you. We'd also like to thank very warmly Mr. Raphael Owunzuligbo for sharing his experience with us today. We're really grateful. We hope that when next we call you, you would oblige us. Ladies and gentlemen, I'd like to remind you that the sessions continue tomorrow and on Saturday. Tomorrow we would commence at 2 o'clock, at 3 o'clock because of the Jumat service. Tomorrow's sessions will run from 3 to 5 p.m. And on Saturday, the sessions will run between 12 noon and 2 p.m. as usual. Thank you all very much for your time. I look forward to seeing you all on the sessions tomorrow. Enjoy the rest of your evening. Bye.
Thank you.
Hey. Oh, yeah. That is this guy. Go and fuck the outside. Yes. So up the.
Yes, yes.
It's on the system, you will see it. Off of this thing. No. Off of this one.